The Senate Committee on Natural Resources will now come to order. Will the secretary please call roll?
Chair Cruz Crawford,
Here.
Vice Chair Scheibel,
Here.
Senator Pizzina,
Present.
Senator Hansen,
Here.
Senator Elson,
Senator Ellison will be here shortly. Please mark him present when he arrives. Welcome to our audience here in Carson City. It looks like we have some people in Las Vegas and those joining us remotely. Before we start, we have a few housekeeping items. When you are testifying, please turn on your microphone, green to speak and off red to listen. We have listeners and viewers online and in Vegas, and we'll be recording this meeting, which will be available on our legislature's website following the meeting. If you have handouts for the committee, please provide 10 copies to the committee secretary. In addition, any exhibits or amendments must be submitted electronically, PDF, to our committee manager no later than 3:30 p.m. the business day before the meeting. And committee information is available on Nellis, which can be accessed through the legislature's website. You may watch our meetings on Nellis or through the legislature's YouTube channel. We ask that public comments be kept to 2 minutes, and written public comments may be submitted before, during, or 24 hours after the adjournment of the meeting. Members of the public may provide testimony on a bill either in person or by telephone. And finally, please mute your electronic devices. Okay, so today we're going to have two hearings. We're going to have Senate Bill 342, but we're going to do that second because our presenter is in another meeting. So we are going to start with Senate Bill 405. I will now open the hearing on Senate Bill 405. This measure creates a Transit to Trails Task Force. I'll give it a minute for our committee member to come, and Olivia and James. Okay, perfect. And is this James? Okay, perfect. Okay. We have today Senator Pizzina, Olivia Tanager, and James Mortensen. We have allotted 15 minutes for your bill presentation. Please begin when you're ready.
Thank you so much. Good afternoon, Chair Cruz Crawford, Vice Chair Scheibel, and members of the Committee on Natural Resources. For the record, my name is Julie Pizzina, representing Senate District 12, covering parts of Las Vegas and Henderson in Southern Nevada, and I'm pleased to be here today to present Senate Bill 405, along with two illustrious presenters joining us, and this would create the Transit to Trails Task Force. This bill aims to create a framework that bridges the gap between public transportation and trail access, fostering a more inclusive and sustainable approach to outdoor recreation. With me today to present is Olivia Tanager with the Toyabe chapter of the Sierra Club, as well as an amazing student who will be up here shortly. And I'd like to provide just a few brief remarks before handing it over. The past interim, I had the honor of serving as chair of the Joint Interim Standing Committee on Natural Resources alongside Vice Chair Scheibel. And during one of our meetings, we heard a wonderful presentation from Nevada's Division of Outdoor Recreation within the State Department of Conservation and Natural Resources that discussed the importance of outdoor recreation in Nevada. I also had the opportunity to have many conversations with Ms. Tanager in regards to the Transit to Trails Task Force program, and an idea was born. We're fortunate to live in a state so renowned for its diverse landscapes and abundant opportunities to enjoy the outdoors. However, many communities face barriers in accessing these areas due to limited transportation options. The existing infrastructure simply does not provide reliable means to reach these trailheads. Additionally, that lack of infrastructure can also pose various public safety concerns. This is especially true in the beautiful Lake Tahoe Basin, where parking challenges and weather conditions have the potential to create dangerous situations. During the interim, the Toyabe chapter of the Sierra Club mentioned legislation to find solutions to these problems, and that is how we find ourselves here today with Senate Bill 405. So I would love to hand it over to my co-presenters.
Thank you, Senator Pizzina, Chair Cruz Crawford, and members of the committee. My name is Olivia Tanager, Director of the Sierra Club's Toyabe chapter, for the record. And we actually have two students here today with us. So first I'm going to kick it over to Mr. James Mortensen, and then we'll hear from Miss Ebony Martinez, and then I'll finish up and walk folks through the bill, if that's okay. Thank you.
Good afternoon, Madam Chair and members of the committee. For the record, my name is James Mortensen, Jamesmortensen. Thank you all for the opportunity to speak in support of Senate Bill 405. Trails and outdoor spaces are very important in my life, and I believe more kids and family can benefit from them if they were easier to get to. I have been using trails for as long as I can remember. I have seen pictures of myself as a baby in a carrier with my parents on the trail. Being outside is our family personality. I don't know who we would be as a family if we could not go outside. I have the opportunity to hike or backpack in several national parks, including Great Basin National Park in eastern Nevada. On my wish list is a trip to southern Nevada to go rock climbing in Red Rocks. The trails here in northern Nevada are where I most often spend my weekends. The trail has provided an opportunity to do many sports such as skiing, rock climbing, hiking, camping, and backpacking. It has also allowed me to spend time with my family and friends. When I am on the trail, I can worry about nothing and focus on fun. I don't have to think about school, and the thrill of being unplugged from our electronic world is refreshing because on the trail, the games are provided by nature. Having a car shouldn't stop you from accessing a trail because what carries you on the trail is your feet. It seems silly that other kids can't walk on the trail with their feet because their families may not have a car. I have found real joy in the outdoors that doesn't involve a screen. I think everyone should have the opportunity to experience that.
Good morning. My name is Ebony Martinez, good afternoon. My name is Ebony Martinez, Eveny, and I wanted to talk a little bit about my own personal experience with not having access to public transportation. I am a woman who likes to be independent and doesn't like to ask people for favors. So a couple months ago, I did get into a car accident, so I did not have a car availability. So it did keep me away from going outdoors, and there was a couple of sunny days that I wanted to go on a hike and go for a run, but I wasn't able to get there. I would say that people being able to get to access to transportation is such a big thing because even with me, I come from a club called Adventure Club at Proctor R. Hook High School, and one of our biggest challenges is getting transportation. Not too long ago, we did go on a trip to Chickadee Ridge, and in that moment, I felt relieved. I felt happy that I was able to get there, even though did not have access to a car. And I do believe that other people should be able to have access to that as well, because it's a way to get outdoors, to see how the world is outside of technology, especially how advanced AI is getting right now. And I do think that being able to have Sierra Club to be able to give us the transportation that we need is such a blessing that I really enjoy having. And I've also talked to other people about, how they went with Chickadee Ridge, and they said it was a life-changing event. Not only is it a good thing to go out, but I do think that it is helpful for future careers because at Chickadee Ridge, it was a very bit difficult because of how tiring it was, but it did push me to push past my limits, and I do think it would help for any careers at all to learn how to work with other people, how to multitask, how to just get out of a situation like that, basically just to get out of their own comfort zone. Thank you.
Thank you so much, committee members. My co-presenters up here with me and Senator Pezzina really spoke to the need. You heard that a lot this afternoon, the need to make sure that everybody can get outside. Because right now in so many places, getting outside is a privilege for those who can afford a car and for those who can afford gas. And so if we can get more folks outside, it'll improve both public health and public safety. You heard Ms. Martinez mention she went on a hike with the Sierra Club, and so we have two programs that I wanted to briefly mention today. Inspiring Connections Outdoors that seek to get young folks outside who might not otherwise be able to get outside. So we have an ICO program in Reno and an ICO program in Las Vegas. And like you heard, the biggest hurdle that we have heard consistently from students in getting outside is the lack of transportation. And the biggest hurdle in getting communities in the inner core of our urban areas outside is transportation. And for that reason, Nevada is really well suited for a transit to trails program. We have so many amazing outdoor recreation opportunities that are so close to our urban areas. We've heard stories from kids in Reno who have never been up to Lake Tahoe, and we've heard stories from kids down in southern Nevada who have never been out to Red Rock because of the transportation limitations. So I think the need for this kind of program is obvious, and that's why we're putting together this Transit to Trails task force to figure out how we can eliminate those barriers and how we can get public transportation running to trailheads. So I wanted to talk about some other conversations that we had in the course of the interim. I talked to some folks about the public safety associated with transit to trails. And like Senator Pazina mentioned, folks who are going up Mount Rose Highway or folks who are going up the Spring Mountains in southern Nevada go in the winter oftentimes for skiing and sledding and things like that. And it is a huge drain on our public resources because then folks have to go up and get rescued. And so if we had public transportation, it also eliminates those safety risks associated with some people trying to recreate outside in inclement weather. So with that, I'm going to go ahead and list out the folks who are on the task force and then talk about our conceptual amendment that was submitted. So on the task force, we have one representative from the Office of the Governor, one member of law enforcement because of the feedback that I mentioned that we've gotten about traffic and other concerns related to vehicle towing in the winter, one member of Southern Nevada's Regional Transportation Commission, one member of the Washoe Regional Transportation Commission. We did want to make sure we had a representative from a non-Washoe, non-Clark County, and so that's included on the task force, one member from the Division of Outdoor Recreation, two members of the public, one representative from the U.S. Forest Service, from the Bureau of Land Management, and from the National Park Service. And we've already talked to a lot of those folks in the interim about the need for this, and I know a lot of those folks are really excited too because of some parking limitations that Senator Pazina also mentioned. So those are the folks who are currently on the task force. We do have a conceptual amendment to add the Tahoe Transportation District because the situation in Lake Tahoe is very unique. And so we were approached and asked to add a seat, and we thought that was very reasonable given some of the issues that we've seen in the Tahoe Basin with parking and access to outdoor recreation. And then the other piece of the conceptual amendment that we submitted was broadening it a little bit because we got feedback from some older folks, from some folks who are disabled who want to be able to use this to get outside as well. And so we are looking to broaden the language from trails to outdoor recreation areas, and that'll also open up the avenue for folks who are wanting to go snowshoeing or wanting to go sledding or things that might not necessarily be designated trailheads but are outdoor recreation hubs. And so I think that kind of summarizes the intent of the bill, what the bill does. I will note that there is presently no fiscal note attached to the bill. And so with that, I think we're ready for questions, unless Senator Pazina, you wanted to add anything else? Okay, we are ready for questions. Thank you.
Are there any questions from the committee? Oh, great. Awesome. I do have a couple of questions. Are there any other programs that you looked at other states that do have transit programs that are successful?
Yes, ma'am. Olivia Tanager, for the record, thank you for the question, Senator Cruz Crawford. So there are a few other states who are looking at doing this, and in New Jersey, I know they have a Rails to Trails program because they have rail infrastructure. Obviously, that might not be well suited for the state of Nevada. Illinois and some other states also have transit to trails programs, and Illinois is also looking at similar legislation this legislative session. So there are other states that have transit to trails. There are also other states who are looking at biking initiatives, so making sure that there are bike paths to trails as well. So yes, there are a number of other states that are doing this, and from what I've heard from folks in New Jersey and Illinois, it's been very successful in getting folks outside who might not otherwise be able to get outdoors.
Thank you so much. I really appreciate this. I really feel like the love of outdoors is a learned skill, and the more that we expose our young people to it, we're supporting the next generation of taking care of our land. So I appreciate that, and I agree. I have students all the time I take on a field trip 5 miles from the school, and they've never seen, some outdoor spaces. But I do want to say that you really tugged at my heartstrings and by bringing the kids here, so thank you for that. Okay, perfect. So we are now going to start with testimony and support. So if you'll just step back. And if you would like to testify in support of Senate Bill 405, please approach and begin when you're ready.
Good afternoon, committee. Devin Middlebrook, Tahoe Regional Planning Agency, MIDDLEBROOK. Here to offer our support for this bill and appreciate the inclusion of a Tahoe seat through that conceptual amendment. When we first saw this bill draft request come out, we were very excited because, as mentioned in Senator Pacina's opening, Tahoe has lots of transit and lots of trails, or not as much transit to those trails. And with 1/3 of state parks visitation happening at the lake, really want to make sure that we're providing equitable access and more access to folks via transit to those beautiful recreation sites to reduce congestion and impacts to the environment. Just to also emphasize Senator Pacina's point about folks that don't necessarily have easy access to a car, 3.6% of Tahoe's residents live in zero vehicle households. So that's 3.6% of our population that this will directly help. And we look forward to contributing to support not only access, but also protect the environment, support local communities and businesses, and leverage other sources of funding to achieve the goals of the task force. Thank you.
Good afternoon, Chair and committee members. My name is Nicole Flangus, last name spelled Flangas, here on behalf of the Nevada Outdoor Business Coalition. We are here in support today of SB 405, which creates the Transit to Trails Task Force. We believe our state's outdoor recreation industry has the power to invigorate communities and drive economic growth. One of MBOBC's core missions is creating a more connected outdoor recreation industry in Nevada. The creation and mission of this task force to identify public transit location priorities, apply for grants, and basically get more Nevadans connected with the outdoor landscape is within our mission and vision. We urge your support of SB 405.
Thank you, Chair and members of the committee. For the record, my name is Christy Cabrera-Georgeson. I'm the Deputy Director of the Nevada Conservation League, and we're here in support of SB 405. NCL has been longtime supporters of getting more Nevadans, especially kids, outdoors, and this is a necessary step to make sure the wonderful landscapes Nevada has to offer are accessible to everyone. We urge the committee's support. Thank you.
Hello, Chair and members of the committee. My name is Jana Moan, and I am the Nevada External Affairs Director for the Nature Conservancy, and we're here in support of SB 405 to create the Transit to Trails Task Force. We feel that this effort will enhance equitable access for people of varying economic levels to visit and experience Nevada's amazing places, our beautiful trails, our parks, and expanding those opportunities for all people to experience nature can improve public health while also alleviating vehicle congestion at crowded trails. And so we just want to say thank you to the Sierra Club and to Senator Pacina and to all of you for hearing our comment.
Madam Chair, members of the committee, thank you for allowing me the chance to comment. My name is Kevin Burles, Kevin Burls. Today I'm here representing the science education nonprofit Nevada Bugs and Butterflies. We're a Reno and Northwestern Nevada-based organization, and since 2012 our work has supported conservation of Nevada's native insects, and we also have provided community education opportunities and resources about Nevada's insect communities. We support this bill because facilitating access to public trails and recreation opportunities allows the public to enjoy our amazing natural places across our state and enjoy the diverse plant and animal communities found in these areas that can be close by, but are still inaccessible to individuals who do not have available transportation. In addition to wildlife viewing and recreation and opportunities, I would like to point out that public transit is a perhaps surprisingly important part of research and community science programs, which allow scientists and the public to participate and collect valuable data in natural areas. In fact, one of the longest running butterfly monitoring programs in the world, just run over the mountains in Central California by Art Shapiro, who's a professor at the University of California, Davis, has somewhat famously been run since the 1970s at sites picked explicitly along the I-80 corridor, and Dr. Shapiro has used public transit for many of his surveys since the 70s for these locations, which he completes every 2 weeks throughout the summer months. A little bit closer to home, just one more example from our state and our organization. One of our organization's longest running programs is the Nevada Butterfly Monitoring Network, which is part of a national community network providing long-term monitoring data. Two of our most dedicated volunteers in this program, Jeff and Eileen, travel only by public transit, and their data have contributed to the most recent publication using this information, which was just published in March of 2025 in the journal Science. Many dedicated amateur and professional naturalists use public transit to document and enjoy our natural history and diversity of our state, and this bill will help support Nevada citizens in this pursuit. Thank you for supporting SB 405.
Thank you. Looks like we have 3 young people down in Las Vegas. They're taking some great selfies up here, documenting the legislative process for their homies on Snapchat. I appreciate that a lot. Seriously, whatever you can do to communicate to others about this, and I thank you for taking the time. So you may begin when you're ready. Please state your first and last name for the record, and you have 2 minutes. You may begin.
Thank you, Senator Cruz Crawford. Hi, my name is Flor Diaz. I'm the youth organizer with Make the Road Nevada, FLORDIAZ for the record, and I'm here to support Senate Bill 405. I think this bill is very important because not everyone has a car or access to nature. I've seen how hard it is for people to, especially young folks, low-income families, or people who live in the city, to get out and hike on trails or parks. Creating a task force to look at how we can connect public transportation to outdoor spaces just makes sense. Nature should be fair for everyone, not just for people who can afford to drive there. I support this bill because it's about equity, public health, and helping more people enjoy the outdoors. Thank you for your time.
Good afternoon, members of the committee. My name is Samira. I am a student of the Clark County School District. I've lived in Nevada for 13 years, and I am a proud member of Make the Road Nevada. Public transportation has been a lifeline for my mom and me. When we were homeless, it helped her get to job interviews and gave me a way to get to school when I didn't have stable housing. Not everyone starts with a car. Some of us Nevadans begin with nothing. Affordable and reliable transit gives us the chance to survive, grow, and reach opportunity. SB 405 is important because it brings more equity and safety to our transportation system. It would help expand access to places like Sunrise Mountain and local parks that support our mental and physical health, especially for youth and families without cars. Over 100,000 Nevadans rely on public transit every day. Access to nature, jobs, and stability should not depend on your income or whether you own a vehicle. SB 405 helps make that vision a reality for all Nevadans. Thank you.
Thank you, Samara. Can you state your last name for the record? And spell it?
Eddards,
Can you spell it?
EDDARDS.
Thank you so much.
No problem.
My name is, good afternoon, Chair and members of the committee. My name is Angel Diaz. I am 14 years old, and I lived in Nevada my entire life. I'm here today as a member of Make the Road Nevada to express my strong support at SB 405. Public transportation is not a convenience. It is a necessity for families like mine. My uncle, who helps our household, relies on public transit to get to work every day. Without it, he would not be able to keep his job or continue providing for us. SB 405 is more than transportation. It is about protecting people's abilities to survive and thrive. Our communities deserve reliable and affordable and accessible public transit that connects us to work, school, healthcare, and opportunity. Please support SB 405. It is an investment in working families and in the future of young people like me. Thank you.
Thank you. Oh, we still have some more.
Yes. Well, good afternoon, Chair and members of the committee. My name is Hector Arreola, last name Arreola, and I am the Policy Fellow with the Nevada Environmental Justice Coalition. We are a statewide coalition of community organizations fighting for sustainability, justice, and equity in all levels of government decision-making. And together, we build people power through grassroots organizing and policy advocacy. I quickly want to share a personal story of how this will be impactful to our community. I was born and raised here in Las Vegas, and as a child of a single mother struggling through the Great Recession, money was tight. but trips to the greater outdoors became our sanctuary. Red Rock, Mount Charleston, Valley of Fire, and Lake Mead, these places gave us adventure, an opportunity to bond, and an escape when we needed it the most. Some of my most precious memories were formed here on these trails or shorelines of Lake Mead, where the desert taught me resilience just like my mom did. But when our cars started to fail, everything changed. These bonding adventures vanished every time we couldn't afford to repair our cars. We became prisoners of our very own zip code, watching the landscapes that have shaped our family become inaccessible. Public land should belong to everyone, not just those with the access to a reliable vehicle. Transit to Trail addresses this gap in connecting our communities to recreate in the greater outdoors, to community-centered planning, ensuring that public transportation actively connects underserved communities to parks, trails, and open spaces. Thank you for your time and your dedication to the people of our state. Thank you.
Chair and members. Chair and members of the committee, for the record, I'm Deb Reardon on behalf of the Regional Transportation Commission of Southern Nevada, or RTC. The RTC supports SB 405. The RTC is responsible for managing public transit operations in Southern Nevada and recognizes the value of coordinated efforts to expand access to recreational areas through transit, as well as improving our quality of life. The RTC is prepared to work with the task force to assess transit service needs to trailheads and contribute technical and planning expertise where appropriate. We see this legislation as a useful step in exploring transit solutions that align with community needs and outdoor access goals. Thank you so much.
AVH, is there anyone on the line that would like to provide testimony in support of Senate Bill 405?
If you would like to testify in support of Senate Bill 405, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to testify in support at this time.
Thank you, AVH. Now we'll move to opposition testimony for Senate Bill 405 in Carson City. Is there any opposition to Senate Bill 405? Seeing none, in Las Vegas, do we have any opposition to Senate Bill 405? Seeing none, AVH, do we have any opposition on the phone for Senate Bill 405?
If you would like to testify in opposition of SB 405, please press star 9 now to take your place in the queue.
Good afternoon. For the record, Fred Volz, V as in Victor, O-L-T-Z as in zebra. SB 405 lacks merit, fails to demonstrate need, and cannot support a viable service schedule to attract sufficient outdoor seekers. Large and small transit agencies already have grant writers on staff to secure funding from federal and private sources. There are no new government funding sources to pursue in the DOGE environment. NDOT currently administers 4 federal transit administration programs targeting rural transit. No evidence has been presented indicating demand for these services by the public in sufficient numbers to warrant the tremendous financial investment required. Transit systems around the country are already struggling to avoid service cuts given declining usage and funding. The zero financial impact signed off on by both DCNR and the Governor's Office of Finance ignores secretarial services for meeting minutes and reports, research costs, a paid meeting space, payment of member travel expenses, and paid employer leave to attend. It is ominous, too, that only 2 of the 12 proposed task force members would have knowledge of how to operate an urban, not rural, public transit system. Thus, how could they offer useful input into rural transit operations and scheduling? SB 405 is unnecessary, will benefit very few people, and will be astronomical in cost to even attempt, much less operate on a long-term basis. Call an Uber instead. Thank you.
AVH, is there anyone
Chair,
else?
you have no more callers
Thank
at
you.
this time.
Thank you. We will now move to neutral testimony. Is there anyone here in Carson that would like to testify in neutral to Senate Bill 405? Is there anyone in Las Vegas that would like to testify in neutral? AVH, is there anyone on the line that would like to testify in neutral?
Thank you, Chair. If you would like to testify as neutral for Senate Bill 405, please press star 9 now on your phone to take your place in the queue. Chair, the public line is open and working. There are no callers at this time.
Would you like to, Senator Pizzina, would anyone like to come back up in closing comments? Okay, Olivia Tanager.
Thank you, Chair and members of the committee. I'll be very brief. We heard a lot today about the need for this bill. We heard a lot. Oh, I apologize. Olivia Tanager for the record. We heard from a lot of young folks today about the need for this bill. We've heard a lot from community members, and I've heard a lot from some older folks in town who aren't able to get outside anymore because of transportation limitations. So I think the need is very clear and was well demonstrated in today's hearing. And the goal of this bill is ultimately to get everybody in the room together to talk about how to get more people outside in an equitable, sustainable, and safe way. The tagline that we've been telling people about this bill is it gives people the freedom to roam. I know I've been the proudest to be a Nevadan when I'm outside and I'm able to witness Lake Tahoe and all its beauty and go down to Red Rock and all its beauty. And we just want everybody to be able to have that access and everybody to be able to share in the joy of being a Nevadan with the wonderful places that we have in the state of Nevada. So with that, thank you so much for taking time today and hearing from all our young folks and other folks who are really excited about transit to trails. Thank you.
Thank you. I will now close the hearing on Senate Bill 405. Oh wait, never mind. I wasn't supposed to hit that. That was going to be our second one, so psych. Oh, perfect. Yes, he's here. Okay, great. Okay, we are ready to begin our next hearing, which is Senate Bill 342. This is a measure that revises provisions relating to water. We have our bill presenter here. Senator Orenshaw, please come to the table. We've allotted 15 minutes for your presentation, and I know you have a guest on Zoom, so you may introduce them as well and begin when you're ready.
Good afternoon, Chair Cruz Crawford, members of the Senate Committee on Natural Resources. For the record, my name is James Orenshaw. I represent State Senate District 21 down in Southern Nevada, and I appreciate the committee hearing Senate Bill 342. With me to help co-present in Las Vegas is my friend Michael DeLee. Michael and I were classmates at the UNLV Boyd Law School. We were members of the Environmental Law Society. Michael is a farmer in Amargosa Valley. He's also an attorney and a realtor, jack of many trades, but he's also an environmentalist and he cares a lot about water issues. So he's in Las Vegas, and also I have Mr. Thomas Driggs on Zoom. Hopefully, he is an attorney in Las Vegas who is of counsel at the firm of Spencer Fain, and he practices in the area of water rights. So with your permission, Chair, if I could turn it over to Mr. Driggs and Mr. DeLee to walk us through the amendment. There's an amendment on Zoom, which I'd like to direct committee members to, and then I'm happy to stand for any questions.
Well, for the record, Michael DeLee, thank you, Chair, and committee members for the opportunity to present today on SB 342. I'd like to run through the amendment. The original intent of the bill covered retirement program, and that's what you see the most explanations here. There is a bill working its way through the assembly that is substantially the same goal, and we support that bill 100%, and it's just recently got some improvements, so we're excited about that, and we hope that it does pass. So with that, we've seen some opportunities in working out with other members of the water community, some improvements that we can make to administration of water rights, and have had the opportunity to meet with folks from the Division of Water Resources, get their input from Director of Conservation Natural Resources Office as well. And we hope that we have a good solution to accomplish that, but it does actually remove much of the original language of the bill, which we intended to fix in this amendment, but I can see that I didn't do a very good job. So I'd like to run through the proposed amendment here and show you where I messed up if I could. Oh, by the way, DELEE is the spelling of the last name for the record. So section 1, 2, and 3 should actually go back to the original language. And on page 6, that was not achieved there. You can see it, section 6 there. There's still some blue wording there. That's going to go back. I think the color would probably be struck out in purple. That's what it's supposed to be. And that brings us to section 4, which is where we have a description of what happens when a water right is canceled. And Mr. Drake could probably go into a lot more detail about that because he's handled a whole lot more of those than I have. But there's a problem of resetting the priority date of a water right. It's sort of a penalty right now, a very harsh penalty, as you can describe, that is really not necessary. And it's worked around through a judicial function right now because there's not a mechanism in statute to get around that. So what we're trying to do here is put in statute what is happening judicially anyway. And so the text of section 4 would allow for a water right to be reinstated following a cancellation hearing in certain circumstances, but not lose its priority date under certain circumstances. Then moving on to further the end of the section, what's now section 5, there's a curious problem when there's a appeal for a decision of the state engineer that you have to simultaneously file in the court and with the state engineer within that first 30 days. And for some people who aren't necessarily used to practicing in front of the state engineer and handling water rights issues and appealing those, that can be a trap for the unwary because it's no other agency that I'm aware of do you simultaneously have to serve both the state engineer or with that agency and file in the court within that same initial period. There's typically some additional time beyond that to allow for it, either just according to rules of civil procedure, or if you're following the Administrative Procedure Act 233B, there's timeframes that you serve the appeal after you've actually filed it. So by extending that to 60 days instead of 30 days, it starts counting from the time the decision is made, that you would have 60 days to file that service of the state engineer. The first 30 gets you to the court. And with that, hopefully Mr. Driggs is online and can go into detail and we can take some questions. Thank you.
Yes, can everyone hear me?
Yes, we can hear you. Please go ahead and
Yes,
state your name.
yes, thank you, Chair and Committee. And I appreciate the opportunity to provide some testimony that and answer any questions. I'm actually calling in from Arlington, Virginia, so it's a little later here, but I'm happy to provide some additional assistance here. So the object of this amendment language is to simply maybe avoid a situation where for water rights cancellations that usually happen for one of 3 different reasons. When a particular filing is required by the state engineer, in 2 different instances, is missed and the permit is automatically canceled. And then the other one is a cancellation that's as a result of an additional review by the state engineer where the state engineer has determined or alleged that the permit holder is not proceeding in good faith, is not in compliance with the terms and conditions of the water permit. So in that situation, the state engineer can review it, and if he determines that that it's warranted, he can then cancel the permit. In all of those cases, where simply a filing was missed, or when the permit holder is not in compliance and maybe acting in bad faith, the end result is the same in that the priority date is changed under the current law. The changing of a priority date can have disparate and disproportional adverse effects on a water permit in terms of its place in line or in priority in a given basin. Accordingly, a change in priority date in one basin may have no effect, where a change in priority of a permit in a different basin may render the water permit useless, as they may not be able to actually pump water. So the idea of the amendment, or the intent of the amendment, is to take those cancellations that result in a rather, a relatively innocent reason by simply missing a deadline, or those that are actually not in compliance and not with the terms and conditions and otherwise are acting in bad faith, to separate those two and to not unduly punish the people just missing deadlines and then complying after missing the deadline by not losing their priority date. So that's the main intent of the section in section 4 with the amendment language. There is some added language in section 4, where we're proposing some new language in subsection 1 of NRS 533-395. That added language is simply just to help the state engineer administer the process of reviewing permits for potential cancellation, and is unrelated to the priority issue.
Thank you.
Thank you. That's kind of all I have to say.
And Chair Cruz Crawford, James Ornshaw, Senate 21. I'm happy to stand for any questions. And usually when I sponsor water bills, I end up all wet. So I may have to phone a friend with Mr. Driggs and Mr. DeLee on some of the answers.
Okay, well, the way to our heart is those puns. Committee, we'll start with Senator Ellison. Anyone else have any questions? Then we'll follow with Senator Scheibel.
Got a question for you. He was saying that, you had 30 days to, to appeal this into a court. Which court are you talking about, number one? And then two, when are you going to be able to get into court within 30 days?
Chair, with your indulgence, if I could defer to either Mr. Driggs or Mr. DeLee on Senator Ellison's question.
Tom, if you want to take that, you've done a whole bunch of these.
I can answer that, Michael. Thank you. Senator, the particular section you're referring to provides that anyone that disagrees with a decision of the state engineer can appeal that, and that appeal is to district court, any district court in Nevada where the water rights are located. So, for instance, if it's something in Pahrump, that appeal is lodged with the 5th Judicial District. And it's simply just it's the requirement to file that appeal within 30 days, or if not, then that claim or that appeal is time barred. Now, what Senator Orenshaw's bill is attempting to do is correct a kind of a maybe an unintended difficulty in filing this. In most civil cases, when you file something, and then like a civil matter, you file it, and then you have so many days following the filing to serve that complaint on a defendant. In this appeal, because it's an appeal against the state engineer, you have 30 days to file the appeal, but you have to personally serve that on the state engineer within that same 30-day period. As a result, if you're in a rural district that's far from Carson City, where the state engineer is, you might timely file your appeal in that district court on at 4 o'clock on the 30th day, but you then have to personally serve that on the state engineer within the same 30-day period. And at some point that may be difficult to do, given time and distance.
Follow up, ma'am.
Senator Ellison has a follow-up question, then
So-
we'll go to Scheibel and then Hanson. Did you say you had it? No?
So if I got to file an appeal in Carson City, I've got 30 days to do it. And then once I file it, I got to serve it on to the state engineer. And then we got up to a year to have that go to the court in my jurisdiction. Is that correct?
Senator, no, Tom Driggs, for the record. The way it works, let's say I've got a water right in Lincoln County, and I have to, and the state engineer has decided to cancel it or forfeit it, and I have to file an appeal of that decision to forfeit the water rights in Pioche, in the courthouse in Pioche, and I have 30 days to do that. And let's say I've got to go out and find a lawyer, I've got to go out and gather some evidence, and I don't put my petition for judicial review together until the 29th or 30th day. But I get it all typed up, I sign it, and I go to the courthouse in Pioche, I file it at 3 o'clock on the 30th day. Well, the current law requires that I then personally serve it to the state engineer by 5 o'clock that same day. The proposed amendment here is simply to provide an additional 15 days after it is required to be filed by the court to actually get it to the state engineer and personally serve it upon the state engineer. So it's just providing an additional 15 days for that personal service, because you had to file it on the other side of the state.
Okay, Senator Scheibel.
Okay, I think I have a couple of questions. Let me start with, what is the problem we're trying to solve? Are there people who are not able to make these deadlines because they don't make sense when put together? Is the problem that the deadlines are too short? What is the problem we're trying to solve here?
James Orenshaw, Senate 21, through you, Chair, to Senator Scheibel. Through my conversations with Mr. DeLee and Mr. Driggs, I understand some of the issues are there are newer, younger property owners owners who, maybe have never had a water right before and are not familiar with some of the rules in Nevada, affecting them and may not be as sophisticated as owners have been in the past who've had water rights. And I know that was one of the issues we were trying to address. And with your discretion, Chair, if I could defer to Mr. Driggs and Mr. DeLee to address some of the other issues.
Yes, Senator, I think the issue is,
Can you please state your name for the record?
everyone. Oh yes, it's Tom Driggs for the record. In civil procedure, there is there are rights to appeal a decision in a court, or in this case, an administrative agency. And you are given a certain period of time, and in this case, it's 30 days. The state engineer sends you a letter, for instance, forfeiting your water rights. You have 30 days from the date of that letter to appeal that decision. And so again, using my example, if you're in Lincoln County, you got to file that appeal in Pioche within 30 days, 5 o'clock, prior to 5 o'clock on the 30th day. The current law, in addition to just filing the appeal, requires personal service on the state engineer. So when you file it in district court, and let's say, you have all 30 days you to do that. But if you file it on the 30th day, you have to personally serve it on that within that same time period to the state engineer. So you've got to get across the state to personally serve it by 5 o'clock to the state engineer. Now there is an exception that we actually at one time had to litigate with the state engineer because we were having difficulty getting it within that 30-day time period. But there's an exception where if you file your appeal, in any district court in the state, if you put it in the mail and it gets date stamped, your envelope gets date stamped on that 30th day, that satisfies personal service in Nevada. So even though he actually doesn't get it for however many days, 1 or 2 days it takes for the mail to deliver that appeal, it satisfies the personal service requirement because it was the U.S. Post Office stamped that envelope on that 30th day.
Okay.
The amendment language is simply just providing additional time to either stick it in the mail or drive it to the state engineer and actually hand it to him, as is often the case.
So, okay. Sounds like there are a couple of different issues here. I guess it sounds like there are two different issues here. There is a timeline issue, and then there is a method of service issue. And it sounds like you're saying that the only way that you can appeal an adjudication of a water right is by personally serving the state engineer, and you want to be able to serve the state engineer's office by mail or electronically or by some other method. And so let me start with that issue. I don't see where in the statute it says that the state engineer has to be personally served. Can you point me to that provision?
Yes, Tom Driggs for the record. In subsection 3 of 533-450, it says that the state engineer, in addition to filing it in district court within that 30-day period, the state engineer also has to receive, or the appellant or petitioner also has to provide a copy of that through personal service to the state engineer. So it's in, I don't have it right in front of me, but it's in subsection 3.
So I actually do
And it
have
said,
it in front of me, and it says that no such proceedings may be entertained, et cetera, et cetera, et cetera, unless the petitioner's interest has been served upon the state engineer personally or by registered or certified mail at the office of the state engineer at the state capitol.
Yes, yes. So Tom Briggs for the record. So that is the mailing um, service, and it has to be posted. It has to be mailed that day. And again, um, you know, the proposed amendment is just supposed to provide some additional time period. Now, you know, you pointed out, you said electronic service a second ago, and I think that would, if we don't think that it's a good idea to provide appellants or petitioners 15 additional days to get it to the state engineer or mail it or something like that, I imagine the state engineer would be open to entertain receiving service electronically via email. So that would be an alternative that the committee can explore.
So
and ask the state engineer that same question.
So I guess I'm just not completely understanding what's wrong with the current service requirements. I'm also an attorney. I also serve people regularly with motions and orders and not so many subpoenas anymore, but still, you know, everything has a certain timetable that you have to get the service done within. And, you know, I can certainly appreciate in certain circumstances it could be incredibly frustrating to have to effectuate personal service. Or in certain circumstances, it could be, you know, incredibly frustrating to have to effectuate service in a certain period of time. But service is important. And I think it's always kind of annoying. Like, you have to be a stickler for the rules and you have to follow them. And so what I'm not hearing is just like, what is so special about these cases that we have to change the rules because people don't like following them? That's where I'm getting stuck. And I think that's both to the personal service as well as to the deadline. All those motions that I file and serve, they also have a deadline attached to them. And here in the legislature, we do change deadlines with some regularity, but it has to be tied to something. It has to be, you know, we're talking in, is there a report that can't be turned around in 30 days, and that's why you can't file an appeal within 30 days? Is there, you know, are these not direct appeals? Are they petitions that are hundreds of pages long that require more than 30 days to prepare? Or is it just that some people just, why? Help me understand.
Chair, if I could, I'd like to try to clarify. I think I understand the question. Michael DeLeve for the record, through chair to Senator Scheibel. The analogy that I would make, and then I would give a couple of examples as to why it'd be good to understand it this way, would be something like if you had a client that was in a car accident, and instead of having, say, a year, 2 years, possibly 3 years, depending on which statute you're looking at, to pursue a claim personal injury, you only had 30 days. And in addition to that, once you did file in court within that now 30 days instead of the much longer time, you at the same time had to serve that defendant within that same 30 days. So it wasn't a matter of going to court and filing a complaint, and then you start NRCP 4E1, which gives you 120 days to serve, which you can then lengthen by saying, hey, we can't find this person, we need a motion to extend time to serve. Could be longer than 20 days. None of that applies here. You have a decision, and when you get that record of decision, you have 30 days, both to create your petition, which could be rather lengthy, and if you're unfamiliar with water law and you need to go hire an attorney, maybe you didn't do that immediately. You need to find one first, and finding water attorneys probably takes a little bit of work because, you know, I don't know, Tom was great to have around, so everybody out there, please know that he's a good water attorney. At the same time, you have to file it and serve it. That has tripped up people. It has caused dismissals based on a technicality. Now, there's a rule, as we all know, that we'd like to have things heard on the merits rather than trip people up on technicalities. But it's right there in the statute, and it has caused things not to be heard. Other administrative offices in the state, most of whom are covered by the Administrative Procedure Act 233B, don't have this issue. Because under 233B, you have section 233B 130, paragraph 5, gives you 45 days after you file the notice. So you file your petition, which is typically 30-day, that's fine. Then you have 45 days to serve it after that first 30 days. So you add it together, that's technically 75 days. You file it in court, then you have 45 days to serve it. A lot less than 120 days we're used to on NRCP 4, true, but still fair, and people could live with that because you file it in court. Well, what do? You have to let the other people know. That just makes sense. It doesn't make sense for it to be the same day. That's weird. That doesn't happen in any other place that I'm aware of. It's only here. And I don't think it was the intent of the legislature, but that's there and it's been used that way. The state engineer's office, as I'm sure they would want me to point out, is exempt from NR 2333B under, I think it's section 0391I, if I remember right. So they don't follow 233B, and there's a lot of reasons for that. So we don't have a cure for this except to do it right here in the statute. And I think that's what Mr. Driggs was trying to explain, is that this is an anomaly, but unfortunately it has caused some loss of appeal rights to the unwary.
Okay, so then just one more thing to clarify. The timeline that you're seeking to establish in SB 342 is 30 days to file the notice of appeal, an additional 15 days to serve the notice of appeal.
Michael Lee, for the record, I think it actually would work out to an additional 30 days, the way it is here, but an additional time to serve. Yes.
Okay, thank you.
Okay, we have Senator Pazina, and then Senator Ellison has a follow-up.
Thank you so much, Chair, and thank you so much for the presentation. You know, water rights retirement is very close to my heart. We worked on Senator Gokachia's bill quite a bit, Senate Bill 176 last session. Both Senator Scheibel and I worked really hard on it, along with the interim committee during the interim, and then with so many stakeholders between AB 104 and then SB 36, which is kind of honed down to just the water rights retirement portion. And there were, I would say, and I'm looking at some of you in the room who are engaged in that, probably hundreds of stakeholders at certain times. So I guess my first question would be, how many stakeholders worked on this policy? And two, how does this differ in substance to SB 36 or AB 104? And both have already work sessioned out of their committees respectively here in the Senate and in the Assembly.
Thank you very much. James Orenshaw, State Senate District 21, through you, Chair Cruz Crawford, to Senator Pazina. Understood that the original version of Senate Bill 342 did have a lot of similarities, and we've been working on this amendment as to try to address some of the other issues that I believe really differentiates it from those other bills. As to any of the other questions, I'll defer that to Mr. DeLee and Mr. Driggs.
Thank you. Through Chair Cruz Crawford to Senator Pazina, Michael DeLee for the record. And perhaps I didn't make it clear enough. We've actually attempted to remove all of the water rights retirement language from this bill precisely because there are other good measures that are working through the legislature and have a good chance of success, which unfortunately SB 176 last session did not. But I think we get it right this time. So rather than be duplicative of that, we're looking for these cleanup measures that we can help the administration of water rights rather than work on retirement, which we think is already addressed.
Thank you.
And then Pazina has a follow-up, and then we'll go to Ellison.
Thank you so much. I guess my other question would be, you know, how many stakeholders, just because when it, and I'm sure you know this from previous sessions, when it comes to bills pertaining to water, I feel like the work groups expand well out of this committee room into other rooms. There's just so many people engaged. How many people were involved in the discussions regarding Senate Bill 342? And thank you.
Thank you, Chair. James Orenshaw, State Senate District 21. Unfortunately, we've been a little late in working on this bill and trying to get the amendment ready. So I know I've spoken to Mr. DeLee and to Mr. Driggs. We were able to have a really good meeting, I think, with Division of Water Resources. I can't say, the amendment just kind of finalized it today, so I don't know where they're at on the amendment. I have had some conversations with some folks from Water Authority, and I know that they just got the amendment. They want to look it over. So we are a little late in getting in this. So certainly I can't say we've had the kind of stakeholder input that the other legislations had during the interim. I know certainly that Mr. Driggs, because of his extensive work in water rights, certainly, he's in the trenches and deals with a lot of water rights holders and knows a lot of the issues intimately. So I certainly have a lot of faith in him and in Mr. DeLee and their knowledge, of a lot of the issues that a lot of people are facing.
And thank you so much, and thank you again for the presentation.
Senator Ellison?
Thank you, Madam Chair. When I look at this bill, this is a time period to not work. Here's another example. You got a time period that you're going to have to get the letter, you're going to have to get it filed, you're going to have to go find a water engineer or engineer to go through this stuff. Then you're going to have to try to get into a court. I just tried to get boundaries on a piece of property, and I'm a month and a half trying to get an engineer out there just to shoot lines. That's just for that. So if I'm trying to find an engineer to go and try to despunk this, which I hope to God I never do, but if I did, that's another layer that you're going to have to add to this. I hope I'm wrong, but the way this is reading, not only do you got to file it, you got to make sure you get it there, which they have staffed. Do they not? They can't accept a registered letter the minute you get it. I mean, can a staff take it? That's number one. And then two, try to get it into a district court. That's going to be number two. That's going to be a disaster trying to get in. Three, try to get an engineer that's going to have to debut this. That is a problem within that amount of time.
James Orenshaw, Senate District 21, through Chair Cruz Crawford to Senator Ellison. Certainly my intent with the bill and the amendment is to make the process more fair, not to try to create extra layers or extra bureaucratic layers or extra court processes that need to be satisfied. As to some of the issues you brought up here, if I could, with your deference, Chair, refer to Mr. Driggs to address some of the issues about how someone protects water rights under current law and how it might work under the proposed amendment.
Thank you.
Tom Driggs for the record. Senator, I appreciate your question and your concern. But I think I can hope to reassure you and the other committee members that the process, when you're aggrieved by a decision by the state engineer that you have an issue you want to appeal, what you are filing is a petition. It's not laying out your entire case. It's a simple petition that the 30-day period is more than likely sufficient to put a petition together. It doesn't require getting experts on board or that's all left later for briefing. Because again, this appeal, it's an appeal before district court. So there's a whole briefing schedule that happens in months and months down the road. So we're not contesting that the 30 days is not enough time to file a petition. We think that's an appropriate period of time. It's simply just, and as the other senator mentioned, but in my, and I'm not, a litigator, but I'm unfamiliar of any situation where you have a time bar deadline to file something that requires whoever you're serving, whether it's a defendant or another party, within that same period of time. either under the normal rules of civil procedure or any Administrative Practices Act. So again, this is something because we've run into this situation because you're filing something in a rural district. You sometimes some rural districts do allow filing by email, some don't. So sometimes it requires some type of a process server or someone driving hours to a district court. So even though 30 days is an appropriate period of time to file an appeal, that can be burdensome as well. But it's just the situations where you have 30 days and then you have to personally serve, and sure, as has been pointed out, you can do it by mail. It has to be postmarked. But again, some situations where that's also difficult to file in court and then get to a post office to get it postmarked. So again, the amendment language is just requesting a small period of additional time to effect service as required by the statute on the state engineer. But I think again, if we could enlarge the way it's served by doing it electronically, where you could file it and then just simply email it to the state engineer on that same day. I mean, that would work too. But we're just trying to find some reasonable period of time to effect service where it has been difficult in situations before based on time and distance. Thank you.
Thank you.
Quick follow-up, ma'am.
Okay, a
One
quick,
second.
1
Yeah.
second.
Ms. Orenshaw, getting to district court, you got to hire an attorney, do you not?
James Orenshaw, Senate 21, through you, Chair, to Senator Ellison. Some litigants go pro se, but there's the old saying, he who represents himself has fool for counsel, even if you are a licensed attorney. But certainly, I think my intent is not to add more burdens to the water rights holder with the amendment and with the legislation. And so certainly I think here the idea perhaps of email service, electronic service, if that's something the other stakeholders are open to, that might address some of the issues in terms of the difficulty with either personal service or registered or certified mail at a post office, and trying to find a post office open so you can get that postmark to protect your water rights. Because, driving from Pioche to Carson City or finding a post office that isn't closed to get that postmark may not always be the easiest thing. So I think some of the ideas that Mr. Driggs suggested, which aren't in the amendment, but electronic service could solve a lot of problems, because that might be in addition to those other personal service and certified registered mail options that would give people another option to try to protect their water rights. And with the Vice Chair's indulgence, if Mr. Driggs or Mr. DeLee might want to comment on that with your discretion.
Chair Cruz Crawford, Michael DeLee for the record. I just wanted to add that we're actually helping water right owners here. A lot of people that are water right owners are not attorneys. I would probably say the vast majority of water right owners are not attorneys, and hopefully never have to find out about this provision of the law and don't have any reason to appeal the state engineer's decisions. State engineer decisions are pretty good, especially lately, if I may say so. But under those unfortunate circumstances where you do have to appeal, no one out there, and I would say even no attorneys out there, except ones that are already familiar with this, would expect that the same amount of time that you have to file the appeal is also the same amount of time running concurrently that you have to serve it. You don't file it and then serve it. You have to do it all within 30 days. I can file any federal court in the country from my tractor and serve it on the other parties that are party to that. I can't do that sort of thing in most jurisdictions in Nevada, and certainly not with administrative agencies. I think that's for another day. There's a lot of people that would love to have that convenience. I certainly would. But just doing this gives us a lot closer to what other agencies expect under 233B and what we're seeing in the Nevada Rules of Civil Procedure. So we're just trying to give the same benefits that exist everywhere else here. And that's the benefit of water rate owners.
All right. Our illustrious chair has had to excuse herself to go present in another committee, but I think I can handle this. Are there any other questions from members of the committee? All right. Not seeing any, thank you so much for presenting and for taking that time to answer all of our questions. We will now move to testimony in support of SB, is it, I remember 350? 342. Testimony in support of SB 342 in person in Carson City or Las Vegas. I don't see anybody coming forward to give support testimony in person, so we'll go to the phones, please, for support testimony on SB 342.
Thank you, Chair. If you would like to testify in support of Senate Bill 342, please press *9 now on your phone to take your place in the queue. Chair, the public line is open and working. However, there are no callers at this time.
All right, then. We will go to opposition testimony on SB 342. Anybody wishing to testify in opposition is invited to the front now in Carson City and Las Vegas. But I don't see anybody coming forward, so we'll go to the phones again for testimony in opposition to SB 342.
If you would like to testify in opposition to Senate Bill 342, please press *9 now on your phone to take your place in the queue. Chair, the public line is open and working. There are no callers.
All right, then we'll go to neutral testimony. Anybody wishing to testify in neutral is invited to the front tables here in Las Vegas and Carson City. Come on up, please go ahead and give us an indication if you'd be willing to answer questions. Thanks.
Good evening. Adam Sullivan, State Engineer, Division Administrator for Division Water Resources. And we're testifying neutral on this bill, and we're talking about the bill with the amendment. There's two of us here. Malcolm Wilson is the chief of our water rights section. I have some general remarks, and I want to bring it back to the issue of getting a new priority date when a cancellation is rescinded, because I think that's the most substantive component of this bill. And to answer your question, yes, we're available for questions if you have them. Malcolm will talk, he's the expert really with the specific process that would be affected by this bill, so Malcolm's going to run through that. As was discussed by Mr. DeLee in his opening comments, there have been some cases where the courts have overturned a water right holder getting a new priority date when their cancellation is rescinded with the same kind of criticism that it's too harsh of an outcome. And so this discussion comes up a lot. If we do eliminate that provision with this bill, there still should be some kind of alternative mechanism or an incentive for water right holders to meet deadlines. Otherwise, deadlines kind of lose their meaning. You know, I think this gets people's attention that it's an incentive to meet a deadline. And what does this say to the vast majority of water right holders who really do pay attention to these timelines and get things in on time? Holding a water right, comes with some responsibility of ownership, and when deadlines are met, that really helps our agency with keeping things on time and keeping good records and being efficient. This bill, it makes water law more favorable to water right holders who aren't using the entirety of their water right, and it's just a really small piece, this component of getting a new priority date, but that is a larger statewide problem, and I think it's worth bringing up just to be cognizant of when considering this bill. Thank you.
Thank you, Madam Chair and members of the committee. My name is Malcolm Wilson. I am the manager of the water rights section within the Division of Water Resources. When the state engineer issues a permit, it is a temporary allowance that the water right holder needs to perfect In other words, by placing that water to beneficial use. And that permit has two due dates typically. First for filing that proof of completion of work and the other for filing the proof of beneficial use. And these are explicit dates on the permit. The failure to timely file by those dates results in a notice from the Office of the State Engineer that they are past due. You call it a file notice, but really it's past due. And it advises them that, and this again by certified mail, and it advises them that they have 30 days to file either the proof or an application for extension of time within that 30 days, or they'd be subject to cancellation. And so on the scenario where they don't file, they get their water right canceled. We notice them by certified mail of that cancellation and provide 60 days to file a petition with the Office of the State Engineer to review that cancellation at a public hearing. If that happens and we have our public hearing, then if the state engineer makes the determination that he'll rescind or otherwise modify the cancellation, when that permit gets reinstated, it's at that point that the priority date becomes the date of filing of that petition to review, rather than the either original due date or original filing. So with that, I agree with the state engineer with being available for answering any questions on that. Thank you.
Thank you both for weighing in. Are there questions for this? Senator Ellison, go ahead.
I hate to be a pain in everybody's butt, but I'm looking at from the testimony where you started with small little people, 1 acre, 2 acre foot of water outside of wherever. And these people have no idea what the heck they're doing on these small little 1 acre lots or whatever they got. So if they get a petition, a letter saying that you're gonna have to come and refile, or we're gonna jerk your permit, they're gonna have no idea what to do. Cause they go buy a piece of land with a trailer on it or whatever. And that's where the problem comes from. It's not about somebody go out there and say, hey, you got 15 acres here and you got so many acre foot of water, we're gonna contest this. To me, I'm seeing the little people that are out there that's in these small areas that can get this petition, then they gotta go file it. They can probably get that done, but then you're gonna have to go hire an attorney to get it into district court after the appeal. So there's so many things that falls into place. I'm not looking at bigger places. I'm looking at these little bitty ones, and I see some of these places went from, 2 acre foot down to a ½ acre foot, and I could understand that. But I just see some of these smaller peoples out around the whole rural Nevada. If they got these on small lots, that'd be a problem. Could you answer any of that, or because are you just going to take random water lots? What do you? I mean, how are you going to handle this? I don't think you are. Are you going to wait for these guys to go out there and do water cops and say, hey, I want you to go back and file on these guys? I don't know. It just doesn't make a lot of sense to see unless. I mean, this is so broad.
Adam Sullivan for the record. We try to make our noticing and our letters as clear as possible about what the statute says and what the requirements are for a water right holder to follow the law and meet those deadlines. And there's also the option that people can call our staff, and our staff are trained to help people who are unfamiliar with water law to understand what the rules are. So that's how we try to approach that.
And I thank you, but I've been into your office a lot through the years and spent a lot of times on water issues up there, Pete Gogachi and I. I just don't want to see us get into a situation that our phone's going to be ringing off the hook the minute these notices start coming out. I'd rather see the bill go down in flames than do that. I'm worried about the little people. That's what I'm looking at. Thank you.
All right, any other questions? Not seeing any. Thank you so much for your testimony. If there's anybody else wishing to provide neutral testimony, now is the time to come on up to the table. And go ahead.
Good afternoon, Madam Vice Chair. Chauncey Chowda on behalf of the Southern Nevada Water Authority. I was going to talk about what the state engineer talked about in neutral testimony. We just received the amendment today, so we are still digesting it. Hence, we are in the neutral position. But just to kind of talk about subsection 3 of section 4, which the state engineer talked about, it is our view that the state engineer has had some trouble canceling permits. So to have a bill that removes one of the state engineer's tools is something that this committee should look at a little bit more closely. In addition, under this bill, there seems to be no consequences for not filing a permit in a timely manner. So we just need to look at that closely as well on whether this bill would tie the state engineer's hands. So thank you.
Good afternoon, Nikki Bailey Lundahl, Vice President at the Nevada Mining Association. Share the same concerns as the Southern Nevada Water Authority. We were also received the amendment today, so we're working through that internally and hope to be a part of conversations going forward. Thank you.
Madam Vice Chair, members of the committee, Kyle Roerink, Executive Director of the Great Basin Water Network. We've also just received the amendment today. I think I want to uplift the state engineer's comments on priority dates. But Senator Scheibel, I think your line of questioning did really get to an important issue as it relates to what are we talking about, especially in relation to NRS 533-450, which for members of the public and water rights holders is one of the most important statutory constructs that we have if there is a conflict between a rights holder and the division. And I think conversations dealing with those time limits, they need to be done with a lot of different folks, as I think Senator Pizzina implied. So, I really appreciate the debate and conversation, and thank you for your time.
Thank you all. Okay, I don't see anybody else coming forward to give neutral testimony in person, so we'll go to the phones for any neutral testimony.
If you would like to testify as neutral for Senate Bill 342, please press star 9 now on your phone to take your place in the queue. Thank you. The public line is open and working. There are no callers at this time.
Thank you so much. That concludes testimony on SB 342. I'll invite the presenter back up to give any closing remarks.
Thank you, Vice Chair Scheibel, members of the Committee on Natural Resources, James Orenshaw, State Senate District 21. And thank you for hearing Senate Bill 342. I know the amendment got here late. We were trying to address the concerns of all the different stakeholders, and my door is always open. I'd like to keep trying to work with the stakeholders and have an amendment that brings more clarity to the law, protects the little guy, protects newer owners, younger owners, unsophisticated owners, maybe who've never had to talk to a water rights attorney in their life and now are suddenly faced with a lot of legalese that is very hard for attorneys to understand. I mean, we've seen that our Chief Justice now is establishing special courts regarding the water law and special training for judges in water law. Certainly, I know when I read it, I have trouble understanding it, and I took a water law class at Boyd Law School, and I passed. I didn't pass with a great grade, but I passed. But I have trouble understanding these statutes, so I want to keep on working with the committee's discretion and see if I can address some of the concerns the other stakeholders brought. Thank you.
Thank you. And with that, we will close the hearing on SB 342. That brings us to the last item on our agenda, public comment. Anybody wishing to give public comment in person is invited to the front here in Carson City or down south in Las Vegas now. I don't see anybody coming forward, so we will go to the, okay, no one coming forward for public comment. So we will go to the phones for public comment.
Thank you, Vice Chair. If you would like to provide public comment, please press *9 now on your phone to take your place in the queue. Thank you, Vice Chair. The public line is open and working. There are no callers at this time.
All right, then that brings us to the end of our meeting. We do have another meeting scheduled for Tuesday at 3:30 p.m. Just as a reminder, we are getting to that point in session where all of the committees are meeting to try to furiously work through all of our agendas. So we appreciate your patience and your flexibility with us as we start meetings a little later, or sometimes maybe even a little bit earlier. So keep an eye on those agendas. And with that, everybody have a great weekend and safe travels. We are adjourned.